that whether he wins or loses, we are headed for a very fierce legal battle. If he wins, it can be a reason for challenging his election through an election petition that we voted for, or people of Malava elected an ineligible candidate. Ndakwa will be the first respondent. IEBC will be the second respondent. The returning of some Malava will be the third respondent.
As an MCA seeking to vie for a bigger position, for example, MP or senator or governor or whichever elective post that is there, need not resign.
Ni bayana kwamba chaguzi ndogo za Malava zimeweza kuvutia watu wengi sana serikalini na vile vile upinzani. Lakini kikubwa zaidi ambacho ningependa tujue kwamba hii Malava kulingana na mimi naona ni farasi ni wawili. Farasi ni wawili kwa sababu ziko naye Seth Panyako wa DAPK ambaye yuko upinzani, na vile vile tuko naye David Ndakwa ambaye yuko upande wa UDA ambaye ni serikali. Sasa mimi kwangu mimi vile nimeangalia watoto ambao nimeweza kuzungumza nao, naona farasi ni wawili hapa. Na hao farasi wawili kumeibuka swali kati ya mawakili ambao wanasema ya kwamba wanashuku leo uhalali wa yule mgombea wa UDA ambaye ni David Ndakwa. Baadhi ya mawakili wanasema ya kwamba David Ndakwa hastahili kuwania kiti kwa sababu kitu cha kwanza hakujiuzulu siku 7 inavyotarajiwa, na wengine wanasema ya kwamba hakustahili kujiuzulu kwa sababu kuna ile tofauti ya state officer na public officer. Sasa kwa sababu wanasema MCA ni state officer. Kwanza kabisa Echesa amesema ya kwamba David Ndakwa apite asipite, kutakuwa na kesi kotini ya kuhakikisha ya kwamba yeye mwenyewe anaenda kujibu mashtaka ya kwamba hakuweza kujiuzulu na akawa anagombea kiti cha Malava.
And it's going to be a legal tussle whether Ndakwa wins or not, because should Ndakwa win, people will go to court and say they want to contradistinguish between the Wanjiku Kibe case and the Ndakwa case. The Wanjiku Kibe case related to a general election, and the court was protecting the fact that MCAs are elected for a term of 5 years, and therefore to require them to resign before their term ends will be to treat them differently. You know, like Parliament today, members of Parliament effectively lose their seats on the election day, the morning of the election day. So the court wouldn't have allowed an MCA to lose their seats 6 months before the general election. That will be discrimination. So how the contradistinction or to distinguish will come in place is when the litigants will be arguing that the Wanjiku Kibe case was pegged on a general election. The Ndakwa case is pegged on a by-election. And that is why Ndakwa should not be sitting pretty if he goes before a fairly progressive judge. A progressive judge is to find merit or will find merit in any petitioner's argument that Ndakwa ought to have resigned within 7 days of his nomination as per the Elections Act and the IEBC directives that were given. I told you that whether he wins or loses, we are headed for a very fierce legal battle. If he wins, it can be a reason for challenging his election through an election petition that we voted for, or people of Malava elected an ineligible candidate who never resigned. Of course, Ndakwa will rush and rely on the Wanjiku Kibe case. And his opponents will argue that Wanjiku Kibe case was on the general election. His was a by-election. If Ndakwa loses this election, you can take it to the bank that the next week he will go for a small holiday in Mombasa and be back to work into the county assembly and reclaim that seat of Kabras West. That someone will go to court to stop it, arguing that it is an illegality and that even though Ndakwa never resigned, it was the presumption of the law that once he was cleared by his party to run and he accepted to run and he ran, that seat naturally became vacant. And therefore people will be seeking to stop him from going back to the county assembly. On the other side, he would have lost in the National Assembly. It speaks to his chances, perhaps. If you are confident that you're going to win the Malava seat, why then hold the MCA seat this other end by not resigning and struggle to become member for Malava constituency? He's trying to balance, and which balance may eat him up. The Ndakwa case is not to be compared to the Wanjiku Kibe case because by-elections and general elections have different legal parameters within which they are held. So the law is not silent. It is people who are choosing to be silent on what the law provides.
But again, Wakili, if IBC has pronounced itself on this matter and it has given an advisory to Ndakwa, assuring him that he need not to resign under Elections Act 43(6), maybe how is the interpretation of law?
That is the IEBC. IEBC is a corporate person. It has given what we call an advisory opinion. The role of interpreting the Constitution is vested in the High Court. And IEBC's opinion, my friend, it is just like your opinion. Anything that you tell Ndakwa and what IEBC has told Ndakwa has the same legal weight. So IEBC is not a super interpreter. Even the Attorney General, who generally is the government lawyer number one, would advise government, and the court would overturn that advice by the Attorney General. The Attorney General has lost cases severally, yet is the Kenya's finest legal mind in terms of appointments. The IEBC you are quoting has lost an election petition before the Supreme Court, the Raila Odinga case in 2017. IEBC lost. And it is IEBC that will be sued alongside Ndakwa. If Ndakwa goes to Parliament, National Assembly without resigning, whoever that goes to take that petition, Ndakwa will be the first respondent. IEBC will be the second respondent. The returning of some Malava will be the third respondent. If Ndakwa goes back to the County Assembly of Kakamega, IEBC will be the third respondent. The County Assembly will be the second respondent, and Ndakwa will be the first respondent. So IEBC is just giving its opinion. It is entitled to its opinion, and perhaps let Ndakwa rely on that opinion so that whichever way this election goes, we can test the opinion of the IEBC through a legal process.
Kando na hiyo pia nilianza kuzungumza na ambaye ni spika wa bunge la kaunti ya Kakamega.
As an MCA seeking to vie for a bigger position, for example, MP or senator or governor or whichever elective post that is there, need not resign before contesting for that position. That is the position of Section 43 of the Political Parties Act, as you have said, as well as the courts. The Court of Appeal has clearly stated that in the case of Anne Kibe Wanjiku, who was an MCA and vied successfully for the seat at Gatundu North and won. That question arose. The question you have asked me arose, and the court interpreted Section 43 very well. At first, there was a misnomer, which is also existing in Kakamega right now, which is saying that Honorable David Ndakwa should have resigned before contesting for the Malava seat in the current by-election. I want to state categorically that my minority leader, Ndakwa, need not resign before he puts his try in that particular ring for the MP for Malava seat. And the position is because the High Court, in the case that you have just mentioned, had erred by saying that Honorable Anne Wanjiku Kibe ought to have resigned. However, the Court of Appeal cleared that, and it clearly stated that an MCA need not resign because one, he is not a public officer. Our MCAs are state officers. If you look at Section 43, it obligates public officers to resign, but not state officers. And it goes clearly to exempt the kind of people who need not resign. It says the president does not need to resign to vie for a by-election in a position. The vice president, so the deputy president need not resign. A governor need not resign. An MP also need not resign. And an MCA should not resign. They are exempted from resigning. Why? The logic is very clear. These are people who are representing the electorate. Assuming that he resigns, who will be representing these people between that period of resignation and the election?